seminal question being that what exactly is the scope of a civil court while examining a Section 8 petition? To what extent can a civil court, especially after all the amendments and especially in light of the current position of Section 8 of the Arbitration and Conciliation Act, to what scope or to what level can the civil court go and decide on a prima facie basis as to whether the case should be referred to arbitration or the case should continue to be heard by the civil court? This is obviously in those cases when the defendant comes for the first time and files a Section 8 petition. This is, I believe, one important question. The other important question is, to what extent, and the other question is also dealt by the two judgments quite clearly, to what extent does the factum of an invocation of an FIR helps the case of the person who's trying to use a civil court for dispute resolution? So to what extent would the existence of an FIR, or let us say for that matter, the existence of a charge sheet also, help a civil court, help a party to circumvent the arbitration clause by pleading fraud? So these are the two questions. Just one last question is, what exactly is the import of the judgment of N. Radhakrishnan, and how exactly the judgment of N. Radhakrishnan has been dealt with by the present judgment by the Honorable Supreme Court? So in that light, if I can, hand it over to Amit George, just for the knowledge of everyone, Amit George is an expert on the subject. He has more than, let's say, 80 to 90 reported judgments to his credit in the domain of arbitration law, or in and around the domain of arbitration law. And along with arbitration, he obviously practices on other sides, but arbitration remains his area of focus. So Amit Bhai, if you can please take over it.
Thanks so much, Roshan. I am glad Roshan didn't mention how many of those judgments are actually won in. Thank you, Roshan, for those small mercies. But yeah, so yeah, thank you, Roshan, for setting this up. And well, yeah, very interesting issue. In fact, whenever someone talks about fraud or in terms of arbitrability of issues relating to fraud, one thing that always comes to my mind is that eureka moment I felt very early on in the profession, when I stumbled onto the fact that there is actually a principle which says something to the effect that fraud vitiates everything. And to somebody who just entered the profession, that essentially was like a brahmastra of an argument, fraud. Because no matter what you do, you get a decree in your favor. There is an actual full-fledged trial that has happened in your favor. But ultimately, there is still that small potential to be able to overcome almost every aspect that has gone against you if you are able to demonstrate the existence of fraud. So at least, from a meta level, from a meta-analysis, fraud is something which is recognized under our judicial system as something which vitiates everything, and which obliterates pretty much every other finding in favor of a particular party, which he or she may have obtained through fraud. So possibly because of this overarching effect of fraud on the validity of, say, any judicial determination or in fact a document, I think it is very tempting to try and use this as a fallback option when everything else fails. Now, one recent example of how fraud is being repeatedly invoked is in the case of arbitration agreements and instances when parties seek to invoke arbitration by relying on these clauses. Now, this tendency, I think, is quite natural because over the years, particularly after the 1996 Arbitration Act, it has become increasingly difficult to be able to wriggle out of an arbitration proceeding. This is because textually, of course, of sections 5 and sections 8 of the Arbitration Act, which read together, largely circumscribe the jurisdiction which civil courts may exercise. And of course, the judicial precedent, the vast majority of which, except for certain exceptions like the judgment in Radhakrishnan, have mostly leaned on the fact that the arbitrators ultimately do have the jurisdiction to be able to decide almost all elements of controversy between the parties, provided the arbitration agreement is wide enough in scope. Now, in this background, obviously, it is very difficult for a party which seeks to get out of an arbitration proceeding for whatsoever reason, logistical, legal, etc. And the avenues open are very, very limited. So it is but natural that there is an invocation of this overarching principle of fraud as an attempt to try and see if arbitration proceedings can be subverted. Now, I don't necessarily view this in a negative fashion predominantly, because in certain cases, there might be legitimate reasons why this is invoked, and which we will come to when we see the latest judgment, which we are essentially debating today. Now, Roshan had a few queries, which I think essentially also will cover the ambit of what we are planning to talk about essentially today. So one aspect which Roshan pointed out, which I think I'll address at the outset, even though that was the second query, is as to whether the initiation of criminal proceedings necessarily will have a bearing on the determination as to whether there is indeed an element of fraud or not. Now, to answer this, one needs to jog back a little and look at the line of precedent which has actually preceded the latest determination by the Supreme Court. So if one looks at Booz Allen, if one looks at Raza, if it looks at all of those judgments which preceded it, the judgment of Justice Sikri and Justice Chandrachud, where there were in fact two opinions, both concurring, but with different rationale. And when one finds that the Supreme Court has essentially taken a view that, and that is a twin test, which is now reiterated in the latest judgment authored by Justice Nariman. The twin test is that does the allegation of fraud permeate the document itself or the contract as a whole, including the arbitration clause? So the first test essentially lays down the fact that mere simplistic allegations of fraud in relation to possibly the performance of the contract or in relation to the actions of the parties intersay each other will not be a fraud of a level which essentially permits you to completely do a go-by to the arbitration clause in itself. So by necessary implication, what the judgment seemed to indicate is that if there is an allegation of fraud which goes to the root of the matter in the sense that it affects the contract as a whole. For instance, if there is an allegation that the entirety of the contract or the agreement is a forged and fabricated document, the party never signed on it, possibly this is an argument of fraud considering the overall circumstances which might prevail. But the first test is categorical that if your allegations of fraud only relate to intersay actions and dealings, then it would not be sufficient to knock off reference to arbitration. Now, there is a second test which also needs to be met, and which is to the effect that the allegations of fraud should not be of a nature which are of wider societal ramifications. Now, to give like a very rough sort of an analogy, even when we come to the jurisprudence around quashing of criminal proceedings, say under section 482, recently there is an increasing development of the idea that if the financial fraud which is alleged in the FIR in question or the malfeasance which is alleged is essentially of a nature which purely pertains to that specific financial transaction between the parties concerned, and does not really percolate down to or extend to a larger ramification in terms of criminality, then quashings can be essentially effected by the High Court. So in a recent judgment, the Delhi High Court noted that even though the financial transaction was only one, and the party which sought quashing was willing to pay back the amount, the High Court noted that there were allegations that that party which was in default allegedly had in fact utilized services of bank officials to create fake and fictitious bank accounts. So having considered the fact that the element involved in the controversy involved in that particular issue percolated down far beyond what the party's specific transaction was, the court refused quashing. So the Supreme Court, in terms of the jurisprudence around arbitration, also seems to indicate that if there are allegations which essentially deal with wide-scale ramifications in the case of, say, economic offenses, where you may have done things which might actually subvert the economy of the country, or there might be public officials who are involved and who have assisted you in doing what you wanted to do in terms of the fraud or the criminality. So these twin tests have been doubled down on and reiterated in the latest judgment of Avitel by Justice Nariman. Now, increasingly, what is interesting to observe is that the Avitel judgment breaks ground in one very important fashion, and which is the query which Roshan just put to me. So in the earlier judgments, there seemed to be some sort of a very mild textual indication that the existence of a parallel criminal proceeding possibly might be a ground to sort of decipher that this might be a matter which need not necessarily be sent to arbitration, because evidently there was a parallel proceeding which pertained purely to the criminal aspect of it or the criminality inherent in it. But in Avitel, the Supreme Court is categorical in at least two paragraphs. Over two paragraphs, the Supreme Court makes it very clear that merely because there is a parallel pending criminal proceeding in the form of an FIR or any other evidence of criminal prosecution being launched, that by itself would not be an indicator or would not be a signal for the fact that the arbitration proceeding should not be proceeded with, or that this would necessarily clothe the civil court with jurisdiction. So Avitel in that sense is the first, if I may call it that, express enunciation of the judicial opinion that a parallel criminal proceeding is by no means a sufficient indicator of fraud or criminality to the extent that the arbitration agreement itself can be bypassed. And that I think is a very practical perspective, because frankly speaking, in our legal system, as we are all aware, the registration of an FIR is not exactly, let's say, something which is subjected to a very high benchmark. So that I think is a positive development, because otherwise, frankly speaking, almost every arbitration agreement could be subverted by utilization of the argument that, look, there is a parallel criminal proceeding. Now, what is also important, I think, in the context of Avitel is that there is a finding by the Supreme Court that when you talk about fraud, effectively, you can talk about both kinds of fraud, not only in terms of the performance of the agreement, but also the fraud which actually induces you to actually enter into the agreement in question. So the inducement to enter into the agreement was a slightly gray area earlier. But now the Supreme Court in the operative portion of the judgment seems to suggest, in terms of a review of what the parties actually, how the parties conducted themselves, that a fraud to induce somebody into a contract also is something which is seemingly arbitrable. So therefore, this judgment further whittles down the exceptions to arbitrability in terms of its findings. Now, finally, to conclude, I think another very important and relevant finding by Avitel seems to be that the law. So traditionally, everybody, including myself, we have looked at the Law Commission recommendations which resulted in the 2015 amendment as being some sort of a benchmark to actually understand what the interpretation or the view of the legislature is in a negative sense. In what the sense in which I mean it is, when there were suggestions made by the Law Commission, if they did not find mention in the ultimate amendment, then there was an argument that this essentially means that the legislature was unconvinced with that rationale. And therefore, to that extent, the Law Commission recommendation cannot be read. But Justice Nariman takes the view that merely because a recommendation by the Law Commission, in this case, which related to arbitrability of fraud, did not find place in the ultimate statute, that is by no means an indication of the fact that the principle sought to be propounded by the Law Commission was expressly disavowed by the legislature. So therefore, I think Justice Nariman also makes it clear that the mere absence of a reproduction or a replication of a Law Commission recommendation does not express in any way discontent or dissatisfaction with that view by the legislature, and that there would be nothing wrong in the courts actually incorporating those recommendations through judicial interpretation in such cases going forward. Finally, just to answer Roshan's question, so, Roshan, in relation to Section 8, there is an interesting recent judgment of the Delhi High Court by Justice Mukta Gupta. I think it's in July. It's Dharamveer Khosla versus Asian Hotels, in which, yeah, exactly, right. So, therefore, in that, interestingly, in a paragraph, Justice Mukta Gupta takes the view that even post the amendment to Section 8, there is still a fundamental difference in the operation between Section 11 and Section 8. And whereas Section 11 might be constrained to, probably concerned only with the existence of an arbitration agreement, when it comes to Section 8, other elements as well, such as the matter being an accepted matter or the matter in dispute not being amenable to reference to arbitration in terms of the subject matter, etc., are elements that can be considered. So this latest judgment obviously opens up a new area of discussion, because otherwise the general conversation seemed to be that now section 8 and 11 were relatively paramateria. But Justice Mukta Gupta, of course, relies on an earlier judgment of the Supreme Court also to buttress her ultimate finding that there is still a fundamental difference in terms of how an application under section 11 and an application under section 8 has to be approached in the larger scheme of things. So that way, I believe, Avitel, obviously, even though it significantly reiterates the earlier precedent on the issue, on 2 or 3 critical elements, definitely breaks new ground and adds new dimensions to this debate around fraud and arbitrability. So, yeah, that is pretty much what I take.
Yeah, thank you, Amit bhai. Thank you for comprehensively and clearly telling us about the main highlights of the ratio of the judgment. Before I give the floor to Malak, I will just like to ask one question which can logically be it's logically coming to my mind is now is it safe to say that the only cases in which an arbitration clause will be sidestepped or let's say will be circumvented or let's say it'll be ignored are those cases where the one of the parties claims that the agreement was just not signed? Is that the only exception left now after the Supreme Court judgment?
Well, as of now, if you look at it, the judgment as a whole, that seems to be pretty much the only exception. The only other element which I can possibly think of is the national security, exemption. Because in a few cases in the past, before the high courts, etc., when there have been issues with regard to say procurement of say defense equipment, etc., there has been an argument made that this is something which goes to the root of the security of the nation or so and so, and therefore it is something which should not be permitted to go to arbitration. That has had mixed results in the past in terms of how courts have viewed that. Delhi High Court, Bombay High Court obviously have leaned in favor of arbitration. Certain other courts have not so much. So I think that pretty much remains one of the few gray areas that still remains for the Supreme Court to pronounce on conclusively after the amendments. But otherwise, yeah, I agree with you that right now, one of the only explicit ways in which you can avoid one is if you can not conclusively, prima facie demonstrate that there was a clear fraud in terms of the very coming about of the agreement in terms of the physical document.
In terms of signing it or
absolutely,
the inception of it.
Absolutely.
All right. Great. Thank you. Yeah, Malak, please come in. Yeah.
Let me just add one thing to the last comment. While it be a clear paramateria to draw, but if you see the definition of fraud which was given with respect to bank guarantee matters especially, over a period of time, courts have said that because one of the only 2 exceptions for staying the invocation of a bank guarantee is fraud. And the definition now which has been taken to the hilt is it has to be egregious fraud which shocks the conscience of the court. So probably while practically Amit is right, we can't really see anything going beyond the fact that I have not signed the agreement. If one has to theoretically take the definition of fraud as an exception in arbitration, one can still draw some parallel to that level of fraud, that it has to be fraud which shocks the conscience of the court or is a fraud of egregious nature.
But Malak, has that been recognized in the judgment by Justice Nariman?
No.
So that's the only point that,
Yeah, and Malak is essentially telling me ways on how I can continue to make money despite So thank you, Malak.
You see, we at IDRF believe in, supporting each other in the best possible ways. So we keep trying to, devise ways for doing the same. But anyways, now it's up to you. Malak, the floor is with you now.
I don't want to, and I would just leave upon a question which we can now start discussing on. And we'll start with Amit, obviously, on this because he's been doing this. So if you read the judgment as a whole, obviously everyone knows the trajectory of how the judgments have developed over a period of time. One very interesting bit in Avitel, which obviously gets carried forward to Deccan also, is that Justice Nariman draws a lot of inference from section 10 and 17 of the Contract Act. And once you look at 17 falls in the chapter of void and voidable contracts. The fact that and this is coming back to the question on whether the fact that I was induced into entering into the contract, and considering that in Avitel he has said that also is an arbitrable issue. The formation of and the way the scheme of how the Contract Act is made is that void and voidable contracts have been treated as a category where the very fundamental basis of the contract goes away, especially in cases of section 17, where if fraud or misrepresentation has led to the formation of the contract becomes void. Now, if leave apart the argument for a minute that the arbitration clause is an independent contract. If I have to take that logic and fit it into the fraud exception, I don't see parity between the final reasoning and the fact that once you've looked at 17, it's HSBC's argument had very well been that had I known that there was actually no existence of a contract with BBC, I would not have signed the SSA. But having said that, do you think it's a right thing which is done that you have accepted even that out of the fraud exception and made it an arbitrable issue?
No, in fact, Madhav, thank you so much for bringing this out, because this was a slight discomfort I felt when I actually read the judgment. Because as you pointed out, in the reasoning with regard to the distinction between these two kinds of fraud, even though they are both brought within the rubric of arbitrability, the discussion seems to indicate that the fraud in relation to, say, the bringing about of the contract is of a very serious nature. So I was actually, in fact, hoping for more discussion in terms of whether any element of this can actually rise to a level, whereas you pointed out, where the arbitration clause also would be something which would then get compromised. Now, interestingly, in paragraph 22, which is why I refer to the operative portion, in para 22, the judgment then goes on to say that HSBC, having been induced in that sense to come and get on to this contract, is something which does not take away from arbitrability at all. So as you rightly pointed out, generally our understanding was that at least when it comes to fraud as to the very initiation of the contract, and when I'm talking about initiation, I don't mean, as Roshan mentioned, the signing of the document, but in terms of the inducement to enter into a contract, you're right. I mean, in terms of the understanding of the law so far, that is something which is of a very, very higher level than, say, fraud in the performance of the contract. But ultimately, I think the unarticulated premise seems to be that, that separate existence of the arbitration agreement is something which essentially trumps almost all of this. That is not specifically articulated, but I think that is the underlying rationale where ultimately HSBC is, determined to have entered into the contract because of a completely wrong foundation or promise given to it by the counterparty. But at the same time, in one line, the reasoning is that this is something which will essentially go forward for arbitration. So like you rightly said, if I try and justify this reasoning in terms of the independent existence of an arbitration clause, which is of course a well-established principle, then it gels. But yeah, in terms of the specific discussion in relation to the difference between these two kinds of fraud, that I don't think there is much of a discussion. Absolutely. Absolutely.
But right. Amit bhai, again, a related point. Yeah. I believe there was a discussion with regard to voidability and void. Right. What can be voided and what is void. So, right. To that extent, if I read it correctly, Justice Nariman was trying to make a point that if a contract has been wrongly induced into to be signed by a particular party, then it is a voidable contract.
Right.
And one of the parties who's been, cheated or who's been wrongly induced,
true,
can void it at his option and at his discretion.
True.
So, I mean, at the end of the day, the party who's been wronged, the party who's been defrauded, that party should always have the option to either arbitrate or not arbitrate.
Right. So, Roshan, see, I see where you're coming from, but ultimately here, at least in terms of the decision in the para 22, there is no question of choice. There, the judgment seems to indicate that if this is the case, it is necessarily arbitrable. So that's the slight difficulty. I agree that, if that choice was available in the sense that you throw out the document if you want or you keep it if you want, that may be a different issue. But here in 22, there seems to be a finding that something of this honor, if ever occurs, is something which will be an arbitrable dispute. And in terms of inducement to enter into a contract, there could be like all sorts of permutations and combinations. Somebody may say somebody took a blank signed my signatures on blank signed papers with the representation that he will only use it if ABC happens, but he otherwise used it. So that is a slightly different honor. Now, how do you deal with that? So now textually, the judgment seems to indicate that as long as the document itself physically is not tampered with, then seemingly you should go forward for arbitration. So that's what, as Malak pointed out, that distinction in terms of the seriousness of the allegation and why ultimately in para 22 HSBC is still held entitled as a matter of right to arbitrability is something which I think didn't witness a lot of adjudication, though of course the unarticulated premise is clear.
Right.
Because this was also one peculiar case where HSBC, despite being defrauded, was the one which went to arbitration and got the favorable award. Yes.
Yes.
It typically you would see cases where the defrauded party would actually not be wanting arbitration.
Correct.
And because now it's not just on a practical reason, but also saying that since I've disputed the entire document, doesn't make sense for me to take one approach on the document and then still at the same time go for arbitration. But I just have the only two things which I could really get out of this. Probably it's not written in the judgment. Is Roshan rightly pointed out. So I think to Justice Nariman's mind, he has tried to create the distinction between void ab initio and voidable contracts, which probably is not coming out in the reasoning. But he says these are not non-est documents as such. The fact that the factum of the document still exists, and hence your arbitration agreement still exists. Number two, if you come to think of it practically, what would happen if this argument is to be taken forward, which is that the inducement to enter into a contract by fraud would not be within the would actually be in the fraud exception. One can very effectively mold every fraud argument into that sphere and try and make it a big bubble. So if there is in every fraud matter, I can always take it back to the root and say, not just on performance, but the fact that you lied to me about this or you misrepresent this to me, I would not have signed the contract. And practically, I'll tell you the reason why I'm bringing this is we are also seeing this a lot in our criminal cases where banks suing for fraud is atypically, if anything wrong has happened on the financial statements or any wrong reporting has happened, the argument they raise is, had you not made this misstatement or had you not recklessly given false information, we would not have lent money to you, and hence it's a case of fraud. So then to take it at the arbitration level would mean that every argument of inducement or wrongful representation to enter into the contract can be taken to the root of the matter. And probably that's why, to give more weight to arbitrability, that it's been left out from the fraud exception.
Right. Yeah. Thank you, Amit and Malak, for the detailed kind of analysis. So basically, the broader takeaway is that the exception to arbitrability, the exception to invocation of an arbitration clause, has been really whittled down. In all likelihood, if your clients have an arbitration clause, then you'll have to go for arbitration, and there is a very, very small or a very, very minor scope of getting out of that. So on that note, can we open this up for discussion? We still have half an hour left. So if there are any queries or anyone wants to raise any points, please feel free to come in and we can make it more like a round table discussion.
Roshan, with your permission, Chairman sir, with your permission, may I?
My permission is not required. Please go on. Yeah.
Just a question. Yeah. In fact, just taking based on the discussion, Nariman has distinguished section 17 ground as well under two subheads, where he says either you have taken a contract which is contract being obtained by fraud, and on one hand, and on the other hand, the performance of the contract being vitiated by fraud. Now he says that the latter will still fall within the matter of arbitrability, but the former will not. So what I want to put forth is, and I take Amit and Malak's view and Roshan's view also on that, everyone's views, that can on that part we then say the difference between void and voidable, that a void contract will be such a contract which has been obtained, the agreement, the contract itself has been obtained by fraud, that is a void contract. And a voidable contract could be where under the agreement, the performance of the agreement is avoidable. The latter being,
arbitrable.
Under the arbitrability, and the former being not under that exception. And he said so in Abital para 17 of the judgment. I mean, anyone can take that.
Abid Bhai or Malak?
Yeah. So, that's what. So I fully agree. The only slight confusion which arises after that, Shashwat, is that, if you see para 18, essentially both of these are clubbed together under the general rubric of arbitrability. Though, of course, it does not answer whether it is, arbitrable or not. But then when one goes to para 22, in the operative, or not the operative, but where these principles are then applied to the facts of the case, there is a specific finding that even if there is an inducement to that extent in terms of the very initiation or the inception of the contract, then that is something which is perfectly arbitrable. So
Correct. Correct.
yeah. So therefore, that is where I thought, that distinction between void, voidable, non-est, etc. I mean, there was no real, let's say, crystal clear enunciation of why this fell within something which could be arbitrable, as opposed to something which did not. So
Yeah,
I thought,
correct. So,
that.
yeah,
So I
sorry.
thought the nuance in the discussion in terms of the legal principles, which was, let's say, there in paras 15, 16, and 17, somehow that nuance wasn't there so much in terms of the application here, probably
Yeah,
because
that's
it
right.
seemed very clear. But yeah, so that's where I think Malak and me, we're not able to get that sort of connect between what was discussed in extenso and the ultimate application to the facts of the case. That's where a
And
little
which
bit
which
we are,
which happens so often with all of us when we are reading Justice Nariman's judgment. With all due respect to him, but yeah, so Shashwat, if I understand correctly, from my reading of the judgment, both the situations that you've told, both the
Mhm.
situations that you've just mentioned, both will be arbitrable. From if I'm reading this judgment correctly, and I might be, Malak might
No, no,
correct
if
me
you
on
read
this.
para 17, and that's what I thought so. When I read Deccan, that's what I thought so. But then when I went back to Avital, if you see para 17, he makes that clear distinction in Avital. I'm following the SCC copy. So
Yeah,
this
but
is where
the subsequent paragraphs kind of clarify in a little more with a little more clarity that both the cases as mentioned by you will be
correct, correct.
arbitrable, will be
That's
arbitrable.
right.
And that's more so clear from the finding in the facts of HSBC's own case. I mean, it can't
Yeah.
get more uh, uh, clear in terms of the factual scenario, because the inducement here was very clear on a non-existent contract.
Mm.
Also, anyone else wants to come in? Anyone who wants to come in?
But just before anyone drops in, I think that's one of the interesting aspects of reading any judgment of Justice Nariman's, in terms of how well it encapsulates the earlier discussion on the issue, which I think is one of the reasons why that disconnect is felt, because the kind of research is so meticulous, and then ultimately I think to apply all of that threadbare to the facts of each case then I guess becomes humanly impossible. So I think that is one of the reasons why one feels that disconnect in a lot of those
Yes,
judgments.
yes, yes, yes. Can Ujjwal, can you please mute yourself? Pallavi, can we mute Ujjwal, please? Thanks. Anyone else? Samir bhai wants to come in. Bhargavi, you want to come in, or Madhavi, you want to have any comments? For that?
Guys, I'm
So
actually on the way of the worst network, so I'm just happy I can hear you guys while this is going on.
hi Samir.
Hey, wow.
So let me ask a question. I mean, it's not really a question.
Yeah.
But let's open up. So we all, I mean, a large part of the discussion has been around the first leg of the fraud exception. But the most interesting part, which Justice Nariman deals with, which we haven't really touched today, is the second part of the exception, which is in cases where there are allegations against public officials or public bodies, and he says which are amenable to the writ jurisdiction.
Writ jurisdiction, yes.
In cases like, and practically you see that in most tender cases, in most cases where the public authorities contracts are vitiated or are rescinded, or there are disputes arising, one always rushes to the writ court without really having any recourse to arbitration immediately. How do you see the fraud exception with respect to that observation, as that the court will not interfere, or the exception will be used the moment it's something which is amenable to a writ jurisdiction? Because there can be disputes which a writ court can definitely look at, but still remain arbitrable.
But yeah, I mean, so to begin with, I just have one comment to make on that. Isn't every dispute open for a writ jurisdiction remedy? Because writ jurisdiction remedy is a constitutional remedy.
Absolutely.
It has got nothing to do with the arbitration clause or nothing to do with the remedies in personam.
Absolutely.
So I believe, in that context, if we can examine what Malak is saying.
So Malak, absolutely, that is obviously an arena I think which will witness a lot of contestation now, especially after these observations in this judgment. So I think it ultimately, if in a tender matter, of course, there is a judgment of the Supreme Court also that even it's going to be very difficult for you to actually ever and prove malefides in that sense against a public official. So unless I think there is a case of the clear criminality, or corruption or something of that sort which exists, I think any sort of a mistaken notion of how things were to go or something of that sort, I don't think will be sufficient to knock out arbitrability. It's only if there is going to be a serious allegation of corruption prima facie, only then I think these are aspects which may get knocked out of arbitrability. So I think the observations can probably be read in that narrow fashion, at least from my perspective.
Right. So again, going something very similar to the observations made in Swiss timing, where court was concerned with allegations of corruption.
Right. So, but I just wanted to know, regarding this national security exception that I find pretty fascinating, because just like fraud, national security is something, if you look at across our legal fields, whether it be, say, bail or criminal law, etc., this national security is something which is now overriding pretty much everything. So, which is why I found it very fascinating that whether this will actually percolate down to arbitration also. Because recently, whenever the state interest has been invoked, it's primarily been invoked in the context of, say, these, gas production agreements, etc., where national interest is not really in the sense of, say, the security interest. But in future, if you have a defense procurement contract or a defense contractor, and then the state comes up with a security argument, I think it will be really interesting to see how the courts deal with it. That's something which, I think is...
but the only question again that then would be, Amit Bhai, that the agreement in the first place, when it contained the arbitration clause, both the parties did understand that they were dealing with something with regard to national security.
True.
So the subject matter of the agreement would be consistent right from the beginning.
True.
So then, to be able to avoid the arbitration clause, knowing that both the parties knew at the inception of signing the arbitration clause that this was something which is, let's say, relating to the sovereignty of the country.
Right.
To what extent can this be applied? We will obviously have to see. So,
right.
Yeah.
So my only absolutely correct. So now, as I mentioned, for almost everything under the sun now, one standard defense seems to be that there was collusion, there was mass corruption, and that people acted against the interests of the state. So therefore, in a defense environment, it will be interesting to see if a court will actually accept that the fraudulent or the corrupt conduct of, say, an official in relation to a defense deal and the issues which it entails diplomatically or otherwise is something which will be amenable to the jurisdiction of an arbitral tribunal. I'm just wondering because of the kind of emphasis that this has gotten in the last few years in terms of, say, financial crimes or financial transactions.
Right, great. So what else? Anyone else wants to make any query, any point, any addition to what we've just spoken?
Amit and anyone, in fact, can we juxtapose this reasoning given by Narman under section 8 to section 45? Given that 45's terminology is slightly wider, see in 8 there's only prima facie, but if I remember correctly, 45 will be null and void, non-operative, etc. So can we juxtapose that and use it? Because see, I'll tell you what, there may be a situation where an Indian court, following the section 8 analysis given by Narman, hold the arbitration is valid. That and even enforce it here. But it may happen that in another jurisdiction, I'm talking about a foreign award, in another jurisdiction, it may get set aside on the aspect of fraud. So you'll be in a situation where a foreign award is given, where under 45 you accept it here, and it is being set aside there. So that's,
Yeah, I know. That's a very incongruous situation. In fact, that is a very interesting aspect generally in international commercial arbitration as to whether an award that is actually set aside can actually be sought to be enforced. So I think recently, especially after that line of arbitration awards passed against Russia, when it took over all those assets of the oligarchs, and the Russian courts then set it aside, for the mere asking. So I think
also there.
Yeah, absolutely. So there was that line of, so there obviously the enforcement did happen. So yeah, so that's a very fascinating debate in itself. But I agree with you that possibly there can't be a blanket, let's say, use of the text of section 8 while juxtaposing with 45, because naturally there is a different element to 45 in terms of the additional parameters which it
exactly.
But ultimately, see, a large part of the fraud argument, also percolates down into inoperability and all of that. So to that extent, at least, Justice Nariman's judgment, will shut off the, let's say, the tap for a lot of innovative arguments flowing under fraud, which would even otherwise have been utilized under Section 45. So
you
yes,
and Malak, you and Malak will have few less reported judgments, I guess.
no, so now I have to call Malak and say, Malak, please tell me, what do I do?
So see, and which is why I was just going to butt in and at the national security bit is, if you see the trend of judgments flowing from economic offences, especially either at the stage of grant of bail or at the stage of quashing, courts have started reading national security to be paramount and started treating economic offences as the new urban terrorism. We have seen cases where even in a normal IPC offense, and recently I'll tell you an example on arbitrability itself, there is an ongoing arbitration with respect to a client against Gujarat Maritime Board. The contract is nothing but a normal commercial contract for building ridges on the seashore. Because of allegation of corruptions, the court, while dismissing bail, has given observations that this amounts to urban terrorism. This is completely against the paramount national security and the state security, considering that the state has a border with Pakistan, and hence this has now become a reason to vitiate the arbitration. So I don't see there being any dearth in terms of the national security exception not being used. In fact, that is going to be now the new exception which will be created and pondered over. So your work will not decrease by any chance. But yes, it's something which one will really have to look into as to how do you define national security in the context of a fraud exception, because national security otherwise is an accepted form for rescinding contracts for government to take action without any particular definition being there. But in the context of a commercial dispute between the parties, it will have to be seen.
Yeah, Malak, just a point on that. Even prior to national security, even national security will be prefaced by the fact that you still need to prove fraud. You can't just say it's national security, therefore. I mean, you can't put the cart before the horse. You'll have to even prove fraud, that it's been induced by fraud, and therefore. I mean, I don't see a parallel.
So let me take the discussion forward and ask you one more question on that. Is that if I have to prove fraud, if the question, because I can't prove fraud till the time the final adjudication happens.
Right.
And considering Mr. Justice Nariman has said that if the mere pendency of an FIR or a parallel criminal investigation will not rule this out. The fact that, let's hypothetically say, the fact that a charge is already framed with respect to an offense which is akin to a fraud offense, for example, cheating or a breach of trust. If a criminal court has already framed charge, would that amount to prima facie proof that the agreement would fall within the fraud exception? Because it's not been tested till now. We have not. I haven't seen any case where the question has come up that, look, a criminal court has framed charge, so now the fraud exception has to be used. So, any views on that from any of you?
No, I think that, prima facie, that will hold some sort of persuasive value, if not, kind of a binding thing. The fact that charge has been framed.
Right, but that's the only issue, in the sense that, see, generally when we look at the legal principles which we've generally looked at, in the sense of how a criminal court's adjudication would any day bind a criminal court and not vice versa. Correct. But now increasingly, as you mentioned, in terms of the national security exception, or generally the preference which we seem to be giving to the criminal legal system to ventilate a lot of the disputes, I think there is a slight inversion of that process which is happening. And especially when you pit arbitration, which is again viewed as an ADR process, against a criminal court, naturally, at least in terms of the outlook, there is a slight imbalance. And interestingly, Malak, that case which you pointed out with regard to the Maritime Board, I'm not sure if it's the exact same case, but I believe there was a judgment by Justice M.R. Shah in the Supreme Court, wherein he had granted bail to... Yes. It's the same matter, right?
No, for yes.
So there, interestingly, Justice M.R. Shah took the view that because there was an arbitration pending, therefore, it is one of the reasons why he would grant bail. But I was wondering if the Maritime Board ever took an objection on jurisdiction before the tribunal law, otherwise, that, these are elements of criminality, so you can't really touch it.
No, but so I'll tell you what happened after he got bail, and I'll tell you the reason why I brought up this question. After he had an interim order in his favor under Section 9,
Right.
which has now been under Section 17, and
Right.
charges are framed against him in his ongoing CBI matter.
Okay.
Because of which now the GMB has gone back to the tribunal to vacate the interim order on the ground that the exercise was fraudulent.
So they just want a vacation of the order, or have the en masse challenge jurisdiction under 16?
No, they are saying the contract itself is void.
Right.
Which means that Section 16 will come in.
So effectively they are saying, okay, you can't proceed at all, not just with the 17. That will be interesting. Yeah, very, very interesting, that issue.
Because the issue was with respect to corruption with officials. Say the theoretical case that we are talking about, corruption with allegation of corruption with the GMB officials to get the contract when he didn't have the wherewithal apparently to perform the contract. Argument raised by GMB is, since we never had the had we known that this was going to happen, we wouldn't have entered into the contract.
Right. Yeah. So therefore, yeah, that you are right. I mean, that is something which is very, very similar to what we were possibly discussing now in terms of what the future might hold in terms of arbitration going forward. Yeah, because I think at least in terms of arbitration agreements with the state, so I think at least between private parties, this judgment in Avitel to a large extent, I think, takes care of the majority of issues which are pending. But public entities, as you know, because of all these other elements of an inherent involvement of the public interest, I think there is still a lot to be said in terms of how the law might develop in the future.
Brilliant. So I think we've had a good session, and I think we can call it a close unless someone else has any other queries or questions or points to add to this conversation.
Pallavi is obviously silent now. Probably noting everything. And
Pallavi, you're muted.
No, I actually have a question, but I'm just trying to figure out if it actually fits into this discussion. Where you remember Mr. Rohatgi started to argue about the agreement not being stamped and all that. One, how is it that he can bring an additional information into argument, which of course, Justice Nariman goes ahead and says that you cannot be bringing in a new point of argument which has not been taken care of before. And why would he be, there are a couple of things which is not basically what we wanted to discuss. Maybe we want to discuss it at a later stage, but about the bias of a foreign judge, how does one actually get out of it? These are questions which are completely not relevant to today's discussion, and maybe we can look at it some other day. But just a primer first, I think, because you all are all international arbitration practitioners, so maybe Dr. Shashwat and Amit sir may be able to tell us. Malak and I are domestic arbitrators. No?
Malak is Google for us. You give him anything,
Malak
he'll build a rocket, he'll build a rocket today.
He and Riya Chakrabarti, imagine of all the
We're back to the real discussion.
Every time she comes on TV, I'll tell my parents, मेरे friend ने ये matter किया था इसका.
He's going to scar me for life.
No, I think Amit is best placed to answer this. Please.
No. So I think the only international thing about me right now is the fact that I use a Lenovo laptop. That is also not a good thing anymore. So if someone has some non-Chinese laptop lying around, I'll be happy to take it over. So therefore that I think is something which is quite relevant, Pallavi, in the sense that at least these international commercial arbitrations, the difference of cultures. In terms of the applicable law or in terms of the finding. I think very recently in that NAFED judgment, Justice Arun Mishra commented adversely on that practice of the arbitrator. Yeah. In fact, and even I found it quite surprising. But then when I looked it up, apparently it wasn't, it wasn't such a shocking thing. It's completely done in some systems. So that I think is, a serious issue when it comes to international elements involving international arbitrations involving any foreign element. Because the law and the applicable procedure might, significantly detract from what one is comfortable with in terms of the legal system, particularly if one of the other parties belong to a civil law legal system.
Correct. Yes.
Because I remember once doing like a small course. It was like a workshop when I went out for international commercial arbitration, and some of the ways in which they dealt with evidence, I was appalled. I was like, what is happening? How can this be done? So yeah, so that is one issue. And again, like I said, that I think only comes from practice and experience. And that is not something which is, evidently available, at least in most of the jurisdictions in India. So that's definitely a problem. So the same confusion or the same understanding of what constitutes gross criminality, what shocks your conscience, what is like
Correct.
unforgivable fraud, will obviously, that also will have a bearing in terms of what is the cultural background or legal background you're coming from. Definitely, that's a very, very pertinent issue.
Roshan keeps coming up.
Roshan's
All
there.
right, I think anybody else wants to add anything?
Yeah, actually, I just have a query if
Chirag.
we have time for it.
Yeah, Chirag, go ahead, please.
Yeah. So actually, it's a kind of a hypothetical situation. Nowadays what happens is before entering into a contract formally, suppose two corporations have drafted a contract and they are, say, not ad idem on each and every aspect of the contract yet, but they agree on most of them. And some of the aspects of the contract have been left for consideration for finalization. But by that time, they have initialed the contract and they have decided that once they are ad idem on each and every aspect, they will formally sign the contract and be bound by it. So in such a case, suppose there is a dispute before finally signing the contract, but the contract is already initialed, and the contract also has an arbitration clause, of course. One of the parties approaches the court, say for a referral of the dispute to the arbitration. So what can be the outcome of this? Because one of the parties can argue that obviously the contract is not finally signed yet, while one of them will say that okay, we are not necessarily added upon each and every aspect, but most of them have been discussed, finalized, and they have also been initialed. So what can be done in such a kind of a situation?
Right. So just to respond to that, so yeah, actually there are differing views from different high courts in relation to this. I think it all depends to the extent to which the performance will exhibit a intention to conclusively, come forward and actually operationalize the contract. Because if I understand you correctly, there is an arbitration agreement in writing. There is definitely a document in
Absolutely.
writing containing an arbitration clause, but also
Absolutely.
containing a stipulation that it will be acted upon subsequently. Am I correct?
Yes, there is an arbitration clause, but
Yeah.
this thing that it will be acted upon subsequently is not in black and white per se. That was kind of orally discussed between the parties.
So then there will not be any problem in terms of arbitrability, because there can't be, at least at the stage of appointing an arbitrator, an argument that orally we were under the impression that we will only formally start it later. That obviously will not hold ground in a section 11, because in the section 11, the court's only supposed to consider if there is an arbitration agreement existing or not. So
No, no,
therefore,
no. So,
yeah,
so maybe I think I have come
yeah,
across a
that's
little
what. So
wrong.
I'm not very sure of
Yeah,
the
yeah, yeah.
exact,
No,
yeah,
no. The
that
arbitration clause
separation,
is definitely in writing.
right?
Just that it will only come into effect, and the disputes will be referred to arbitration once the underlying contract is also finally signed. So, will it be that, or can it be said that because since some of the aspects have not been finally decided, but the
Right.
contract is initialed and the parties have also started acting upon it? So,
Right.
can then the dispute be referred to arbitration?
Yeah, so just to be very clear, there is an arbitration clause, but let's say after that arbitration clause, there is a specific separate clause saying this arbitration clause will only come into operation once the underlying contract is signed. That's the situation, right?
Correct.
Right. So see, generally nowadays, if you see those line of judgments which say all disputes and differences, etc., if your clause is actually that widely worded, saying all disputes and differences arising under this agreement, then effectively you could always argue that the fact as to whether the underlying contract actually got operationalized or not is also an arbitrable dispute, which is required to be gone into by the arbitrator itself in exercise of jurisdiction under this clause. It will be a different matter, but for instance, in one of those judgments with regard to section 11, when a composite reference was sought, the court said that if the clause is very narrowly worded, if the clause does not say all disputes and differences, then possibly you can say that no, this clause only operates to the dispute on the merits of the contract once entered into, and cannot be stretched to clothe the arbitrator with the jurisdiction to even decide if the contract, the underlying contract, was actually entered into or not. So my answer would be, if your clause is very widely worded, the stereotypical clause saying all disputes and differences, possibly you can still try and articulate an argument that arbitration is required to be invoked, because the arbitrator has the power to determine if that subsequent event which the parties contemplated did in fact occur or not. So I think it will depend on the wording of the arbitration clause.
Right. So
Correct,
my
correct.
question is, will your opinion still hold good if the effective date and the execution date are two different dates? If the effective date is set, say, 3 months later than the execution date.
Let's take a scenario where the arbitration agreement says that 3 months from now, this agreement is going to be entered into. Now, effectively, it is an argument of dispute, because as Chirag mentioned, one party will say we started acting on the agreement. So effectively, our agreement started for all practical purposes. The other party says, no, the agreement did not start, because this was a 3-month period for the agreement to actually come into operation. And we didn't do anything effectively to actually start with the contract. So that amounts to a dispute. Now, if that amounts to a dispute and your arbitration clause is very widely worded, then effectively you can go for arbitration. Now, let me take an extreme case where the contract says that the future contract, let's say 3 months from now, will be evidenced by a completely different agreement or by a different contract. And only in that case will the agreement be deemed to have been operationalized. Then things may get a little bit more complicated, because then possibly what you can argue is that that is an entirely distinct agreement which was to be executed by the parties. A future distinct agreement cannot come within the realm of jurisdiction of the arbitrator with regard to the earlier agreement. That's an argument you could make, but now Section 11 is tailored so narrowly in terms of existence that it will still take some convincing for a judge to hold in your favor if you want to contest arbitrability.
Right. Thank you.
Great. So, Pallavi, I'm sorry I lost the connection a couple of times in the middle. Thanks for taking over. So, anything else anyone wants to add? Because we are out of time now. It's 4.
Yeah, so I just had one query. This is specifically to Shashwat. So Shashwat, what is the current situation with regard to arbitrability? It's slightly different, Roshan, slightly digressing.
No, absolutely. Please,
I'm not at all updated. So what is the scenario today with relation to arbitrability of, say, elements of a dispute which have a tax flavor? So if there is a taxation element involved in a particular dispute, what's the current position in relation to arbitrability? At least when it comes to international commercial arbitration, the recent judgment seems to suggest that possibly, it is something which can be gone into, but both internationally and domestically, what's the contemporary position?
Amit, domestically, under the Act, there is no arbitration. You have a statutory procedure given, you have the statutory authorities, and you go about. I don't think we've ever come across a situation, at least in the recent past, and to the best of my knowledge, where you have a case in which, see, the case will only come when someone applies to arbitration, but no one does. Because the moment an assessment takes place, you have to follow the statutory route. From the stage of assessing officers to the CIT level, then to the ITT and the High Court and Supreme Court. And all this is statutorily given under the Income Tax Act. Even the High Court, how many judges have to sit to hear a matter is given on the statute. So I don't think, I don't know about as much as international arbitrations you would know. I don't think that taxation would be arbitrable unless actually someone moves it and then there's a judicial determination taking place. Under the Act.
The reason I was asking was that recently in a lot of these cases, especially...
Shashwat, can you mute yourself? I think there's some echo. Shashwat, if you can mute yourself. Yeah, thanks.
So the context was that recently there is one of Justice Manmohan's also, though that was not in the context of arbitration, that in a lot of these lease deeds with regard to GST imposition or even generally otherwise, there is this entire controversy as to who is liable to pay, etc. So at least in a couple of cases, I am told there were attempts to try and sort of implead the tax authorities in an arbitration, which obviously did not work out, in the sense that the party which would have succeeded eventually wanted to have an award which would be binding on all concerned. So I am told that didn't succeed. But yeah, so I was just generally curious.
I agree with you. I mean, that's a case where you would have two private parties impeding the government. Unfortunately, in the income tax, you'll have only, the contention against the government. That's the only issue.
No, Amit bhai, to just, I mean, it's very interesting because if you apply chloro controls,
right?
If you apply the ratio of chloro controls, then essentially a dispute of that kind a government party will also have to be implemented.
That's what, yeah.
And they will be liable, because I'm assuming that whatever is decided between two private parties will have a ramification on the exchequer of the government.
True. And in fact, as you mentioned for chloro, etc., predominantly whenever you've had sought to implement PSUs or otherwise, it's mostly in the nature of a contractual relationship. Like there is a contractor and a subcontractor, they fight, and one of them tries to implement the ultimate employer, which is the public sector. So in that context, this is relatively frequent. But I was wondering if it's like a purely private dispute in terms of who's liable to pay. Of course, that's going to be determined contractually. But if while determining it contractually, an arbitrator also is required to take into account, say, the overarching law, which might have, say, slightly step on the jurisdiction of the concerned revenue or tax authority, then it's a somewhat interesting proposition.
Yeah.
In terms
fact, I'll just take 2 seconds on this. In fact, Amir, the example that you gave on the GST issue, you can actually envisage a situation where you have an issue of double taxation. Now, if there are two parties saying that one person has paid, one party is paid, one assessee has paid and the other hasn't, and they initiate a dispute. Now, technically speaking, you may have an arbitration or a direct taxation issue between those two private parties, and they may actually implement this. So that may be an instance where you can actually have arbitration in the direct taxation regime itself, because that will also ultimately impact the tax proponent.
True, because I think the only recent precedent, though of course it's not directly in terms of the subject we are discussing, is that petition filed to injunct the arbitration proceedings initiated by Vodafone in terms of the double taxation which they allegedly have been so there, of course, the High Court had said, I think not in so categorical terms that we can't look at it now, let them continue with the BIT. And I think they also made some concessions saying they will only invoke under one particular BIT and not under the other.
There were also two arbitrations going on that point of time by Vodafone. So that was the other issue which was taken.
Right, absolutely. So there, but the court didn't really get into, I think, in detail this issue of whether a foreign arbitral tribunal could actually pronounce on, let's say, the validity of, the Indian taxation regime or not. So that I think there is no conclusive determination so far. That's
so
also
good for all of us. Good for all of us.
The only difference there is that because in a BIT, the government itself is a party.
True.
So that question may not arise. Probably
Absolutely.
one thing you can explore is that even if the income tax authority may not be implemented, probably the tribunal can ask for court assistance. I mean, that's one way to explore that. That if any query with respect to assessment or liability computation has to come up, the tribunal can always seek court assistance under 27.
True, or call somebody as a witness.
As a witness, correct.
True, absolutely. You're right. True.
Great. So I think we've had a really fruitful discussion. I will fail in my duty if I don't specially thank Amit bhai, because all of us keep discussing amongst each other, but he spared time and gave good inputs and very.
No, guys, I'm really regretting not being able to come for the earlier sessions, but yeah, I had some personal.
I must go to the extent to say that today we have most number of participants. Thank you, Mr. George and Mr. Watt leading the discussion.
Actually true.
That is because of Roshan and Pallavi's strident efforts.
We thought that it was strategic to have you both here so that we can have more participants. No, Roshan, that was the case.
We basically rided on your brand.
Yeah, that's right. Yeah.
He has to go teach a class now. Hey, don't have an Alsar class today.
No, tomorrow. Thank God. Today is not there.
So, yeah, that sounds good. And see you all. Thank you.
Thank you.
Bye.
Thank you, everyone. Take care. Bye-bye.
Thank you, everyone.
Right. Bye. Bye.